Alright people, welcome to Jumbo IS and welcome to lecture number 4 from Polity in this lecture series called Prelims Powerplay 2026. Through this lecture series, as you all know this by now, that we cover or we revise your entire syllabus for UPSC Prelims examination, the entire syllabus. It includes current affairs, segregated subject-wise, and it also includes the associated static topics as well, because we all know that static topics which have some connection with current affairs have a higher chance of featuring in your prelims examination. Definitely there is going to be an MCQ related to that. Therefore, we need to cover the associated static topics. Now, the thing is that this lecture series would be useful for you, extremely useful for you if you follow these 4 steps. Step number 1, never miss a lecture. Every day at 9 p.m. a lecture would drop. Never miss a lecture. Don't keep your lectures pending. These are very useful lectures. And step number 2, along with this lecture, we'll be giving you some notes. The notes would contain the information covered in the lectures as well as some extra information. Memorize those notes. Then step number 3, well, we have enrolled you in our WhatsApp groups. Ask your doubts over there. Those groups are created specifically for your doubts. So use those groups judiciously. Ask your doubts as soon as they occur to you. And step number 4, along with this lecture series, we are giving you access to our prelims test series as well. Be regular with these tests because it's an exhaustive list of tests, and I can understand that if you feel a little lazy or you miss out on a test. But please try not to miss out on any test because tests are the most crucial component of your prelims preparation. So be regular with the tests. This test series is specifically designed for you, so don't miss out on it. All right. Now, as far as step number 1 is concerned, you don't have to worry about that. The lectures will be dropping on YouTube. You can easily access them. But for notes, for WhatsApp groups, and for the test series, you would have to register on our app or on our website. The link, the registration link, is given in the comment section below. You just have to click on the link and you would be guided towards the website or the app, and there you can register for this batch, this lecture series. So register now because not much time is left in prelims. All right. Enough of the introduction. Let's straight away jump into today's lecture. And our today's topic of discussion is freedom of religion, or I should say right to freedom of religion, because right to freedom of religion is a fundamental right. It is included in part 3 of our constitution, a chapter dedicated to fundamental rights. And the articles which give us this fundamental right are Article 25 to Article 28. Now, in 2025, there were some developments in the current affairs which basically highlighted this fundamental right. Okay, these developments were related to 2 cases which were in Supreme Court. One case was related to Waqf Amendment Act, which basically changed the law that regulates Waqf properties. And case number 2 was related to Supreme Court quashing FIRs under Uttar Pradesh's anti-conversion law. Now, both these cases highlighted India's secularism as well as the constitutional guarantees, the fundamental rights from Article 25 to 28. This is the associated static topic. So we will cover Article 25 to 28, and then in the end, we'll talk about these 2 cases because they are part of your current affairs. Okay, so let's quickly begin. So Polity, lecture number 4, freedom of religion. Now, as mentioned before, freedom of religion is covered within the chapter on fundamental rights from Article 25 to 28. Okay, now Article 25 to 28. So right to freedom of religion under Article 25 to 28 is a cornerstone of Indian secularism. By the way, the word secularism has 2 meanings or 2 categories, 2 types of secularisms exist in the world. One is the Indian definition of secularism, which is dramatically different from Western concept of secularism. We'll talk about both these constructs. So these articles, Article 25 to 28, establish Indian secularism in India, okay, emphasizing states' neutrality while permitting reforms for social welfare. Okay, now these articles balance individual group rights with public order, health, morality, and other fundamental rights and DPSPs, which means directive principles of state policy. Now you remember yesterday's lecture. In the previous lecture, we told you that you have 6 core freedoms under Article 19, but those 6 core freedoms are not absolute, right? They have reasonable restrictions on them. Okay, now who would decide the reasonableness? Courts would decide. Similarly, your freedom of religion, your right to freedom of religion is not absolute, and there are reasonable restrictions that the governments of the day, the state, can apply. Your freedom of religion is not absolute. Now, the Constitution mentions those grounds on which the state can restrict your right to freedom of religion. Okay, those grounds are public order. If your religious practice is harming public order, state can restrict that. Health, if there are certain religious practices which harm the health of people, okay, that can be restricted, regulated. And morality, there were certain religious practices which now are considered immoral, like sati or child marriage. Okay, so on these grounds, well, state can restrict your fundamental rights, as well as when the states have to balance this fundamental right with another fundamental right, then also restrictions can be applied. Plus, restrictions can be applied to implement certain directive principles also. But those restrictions should be reasonable. And who would decide whether the restrictions are reasonable or not? The courts would decide. Okay. Now, let's talk about the two meanings of secularism. Okay. So, Western secularism and Indian secularism. Now, hear me out carefully. Okay. Western secularism emphasizes strict separation of state and religion. Okay. State is, different from religion. Religion is considered a private practice and state cannot interfere in religious activities. This is the strict separation. Okay. Even if religious practices are immoral, state won't intervene in that. There is a strict separation. Okay. This is Western secularism. But in Indian secularism, well, India's realities were different. There were certain religious practices which are bad, are not considered good as per modern sensibilities and modern morality. Therefore, state can intervene in a religion to do religious reform or social reform, for social reform. Okay? So in Indian secularism, state can intervene in any religion, in any religious practice to do social reform. But the thing is that state has to maintain that yes, it can interfere, but it will equally interfere with everyone. Okay? So equality would apply. State can interfere with religion, but it has to remain equidistant with all religions. So if it is banning child marriage in Hinduism, it should ban child marriage in Islam as well, in Christianity as well. You understand? So state will remain equidistant, but that doesn't mean that the state cannot intervene. This is the Indian definition of secularism. Okay, though in your notes it will be explained with more clarity. Okay, so but you understand the gist of the matter, right? So this is the thing. Okay, now let's take a look at each and every article. Okay, so there is this table. So Article 25 says that every citizen, every person has right to freedom of religion, for freedom of conscience, which means there is a very important reason why the constitution makers wrote conscience instead of freedom of religion. Because freedom of religion means that you can practice any religion. But what if you don't want to practice any religion? You want to be an atheist, right? So that is why we wrote conscience. As per your conscience, you can practice anything. Atheism, theism, religion, anything. Then, right to profess, practice, and propagate religion. Right to profess means you can openly say that you profess this religion. To practice, openly practice religion. And propagate. Propagate means you tell other people about the good things in your religion. You're propagating your religion. But remember, right to propagate religion is not equal to right to convert people in your religion. These are two different things. Okay. Now, there are reasonable restrictions that are applicable on this: order, morality, and all these things. Then, Article 26, look, Article 25 was an individual right given to every individual, whereas Article 26 is a group right. All religious denominations, like there are religious organizations also, like temple is managed by a temple trust. You understand? So all religious organizations, religious denominations, these organizations, so they form a group, like a temple trust is a group. Well, they have the right to manage their religious affairs as per their own religion. So a temple trust is free to manage that temple as per that religion. Similarly, a mosque or a waqf, or well, any Muslim organization is free to manage that mosque as per Muslim laws. You understand? So these are group rights. Then Article 27, well, gives you an idea how government shall be separate from religion. So Article 27 says that no taxes would be levied to promote one particular religion. that means any public money, government money, won't be spent on promoting a religion, because government money comes from taxpayers. So no taxpayer money would be given to promote a religion. Government won't promote a religion. Basically, it says that. And Article 28, no religious instruction in state institutions. Okay, so all state government schools, state colleges, no religious instruction would be given of any religion. Okay, government schools and government colleges would be free from religion. So this is the thing. Though non-government schools are free to give religious instructions, as there are examples of that in our country. Okay, so these are these four fundamental rights. Now, you need to be aware of certain judicial doctrines that were innovated by judiciary to interpret these fundamental rights. Okay, so key judicial doctrines. Now, look, for example, Article 25 says that you are free to profess your religion. Now, someone might come and say that we are practicing sati again, we are practicing dowry again, and it is part of our religion. And as per Article 25, we are free to practice our religion. So therefore, we will practice sati, right? So, but the government says that we can apply reasonable restrictions. Now, government says that we will ban sati because that comes under reasonable restrictions. But the person says that no, you are violating my Article 25. So who would decide? Courts would decide. And how would courts decide? Well, they apply a test. Okay. And that test is called essential religious practices test. So the courts would see that whether this practice is an essential practice of your religion or it is just a fringe practice of your religion. Whether this is an essential practice of religion, then it is protected under Article 25. If it is not essential practice, it is not essential to your religion, then the government can restrict it. Okay, so sati, government can ban it because courts would say that sati is not an essential Hindu practice. Using this essential religious practice doctrine, the courts allowed banning triple talaq. Because when government banned triple talaq, religious organizations filed a case in Supreme Court saying that you are interfering with our Article 25. So the court said that after research, we find that triple talaq is not an essential Islamic practice. Therefore, the government can ban it. You understand with this example? Okay. So this essential religious practice test, okay, was given by Supreme Court in Shrir Mutt case in 1954. Clear? This is very important. Remember this. Then the courts have clearly said propagation of religion, which is guaranteed under Article 25, right to freely profess, practice and propagate, is not equal to proselytization. Proselytization means conversion. Conversion by fraud or force. Okay. So if you are forcefully converting someone to your religion or via fraud, you're converting someone to your religion, well, that is not your right to propagate your religion. Propagate your religion, propagation is different from conversion. Okay, the courts made it clear. Then Article 25, Clause 2 specifically mentions, Clause 2, Subclause B, that the government can allow temple entry of certain communities. What do you mean by this? In our country, certain temples were closed to certain caste groups. And those caste groups used to say that it is our essential religious practice. So the Constitution made it very clear that you can't say that this is your essential religious practice and restrict temple entry to certain communities. This is made clear in the Constitution itself. There was no judicial innovation required for this. Okay? And the courts have ruled that secularism forms the basic structure of the Constitution and cannot be amended. No government tomorrow, if some government achieves super majority in the parliament, it cannot amend secularism. It cannot remove secularism from the Constitution because secularism forms the basic structure. And I hope you know what the basic structure doctrine is. So this is the thing. Okay. Now, certain landmark cases with respect to freedom of religion, well, these are as following. The Shrir Mutt case, which gave the essential religious practice doctrine. Then Sabrimala case. Women's entry in Sabrimala temple was restricted. Okay. A case was filed by certain women organizations and the courts ruled that these exclusionary practices restricting certain groups from temple entry are not essential religious practice to Sabrimala temple, and therefore women's rights are more important than your freedom in Article 25. So state can reasonably make a law banning this practice of banning women from Sabrimala temple. Basically, women should be allowed temple entry in Sabrimala. Okay, the court said that these exclusionary practices are not essential practices. Okay, then triple talaq case, we have talked about this. Then hijab case, because certain state governments like Karnataka state government banned usage of hijab, the clothing that Muslim women wear. Okay, they said Karnataka government came out with a policy that educational institutions can ban wearing hijab in their educational premises. Okay, now this was challenged in Karnataka High Court as interference in Article 25. Karnataka High Court ruled that hijab is not essential religious practice, so the state government of Karnataka is right in banning it from educational institutions. Then an appeal was filed in the Supreme Court, and Supreme Court basically gave a split verdict. One judge said Karnataka is right in banning this. Another judge said that no, hijab is an essential religious practice. So because there was a split verdict, now this case will be referred to a larger bench of Supreme Court, a constitutional bench, 5-judge bench of the Supreme Court. Okay, so decision is awaited in this case. Clear? Makes sense? Now let's talk about 2025 current affairs. Okay, so key cases of 2025. There are only 2 cases. Number 1 is Waqf Amendment Act. You all know what Waqf properties are. We won't get into that. So basically, Waqf properties are regulated by law. Now the government amended that law. Now, that amendment by the government was challenged in the Supreme Court, and certain problematic provisions in this law were pointed out in the Supreme Court. So what the Supreme Court did was, Supreme Court did not put a stay on the entire law. Certain problematic provisions of that law, but the Supreme Court put a temporary stay on them. That means those provisions won't be implemented. The rest of the rest of the amendment would be implemented. Okay, what were those 2 provisions? Number 1, Section 3, Clause R. Requirement for creating a waqif to prove practicing Islam for at least 5 years before dedicating property as waqf. Look, waqf is donated property donated by Muslims for charity. Now the government came out with a provision that the person who is donating property for charity, and charitable properties in Islam are called waqf properties, the person who is donating the property has to prove that he has been practicing Islam for at least 5 years. Okay. Now, this provision was contested because Muslim organizations said that why did you come up with this arbitrary number, 5 years? Why not 1 year? Why not 2 years? This is arbitrary, and arbitrariness is antithesis to right to equality. Okay, so basically Supreme Court put a stay on this. Then the other provision was designation of an officer above collector rank to decide if disputed waqf property encroaches on government land. Okay, and as soon as he initiates the inquiry to check whether this disputed waqf property is on government land, as soon as he initiates the inquiry, even before his decision, well, that property would cease to be waqf property. So if he initiates the inquiry, and let's suppose after 2 years he finds out that no, it is not on government land, for those 2 years it would cease to be a waqf property. Now this is bad. So this was, these 2 provisions, the courts gave their stay orders on. Okay, and the other news item or the other case was anti-conversion laws. So UP government basically passed an anti-conversion law which criminalizes and prohibits conversion, fraudulent conversion, and other forms of conversion. Now, under this law, many FIRs were registered against people who were accused of fraudulently or forcibly converting certain people. Now, there were certain problems with these FIRs. Okay, so the Supreme Court ruled. Supreme Court basically quashed these FIRs, said that these FIRs are unlawful because you have the right to propagate your religion, and these people were only propagating, not fraudulently converting. So Supreme Court took the side of these people who were propagating their religion or converting other people. The Supreme Court ruled that these FIRs are unjustified. This is executive overreach, and well, right to propagate your religion is a fundamental right. These people are not fraudulently or forcibly converting anyone. So these were the 2 cases. And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure this has added value to your preparation. But please do not forget to memorize this lecture from the notes, ask your doubts if you have any, and be regular with the test when it comes as per the schedule given to you. So with that, I'll take your leave with the promise of seeing you again with another topic in this lecture series called Prelims Powerplay. Thank you, everyone.